Welcome to episode 3 of this mini-series exploring how states respond to civilian harm from their own military operations. I'm your host, Mae Thompson from Ceasefire, the Centre for Civilian Rights, and in each episode we'll be joined by leading lawyers, experts, practitioners and military personnel to discuss the evolving landscape of military accountability, the gaps in existing redress mechanisms, and the potential for a UK civilian harm redress scheme. This mini-series is part of a joint project by Queen's University Belfast, University College London and Ceasefire, aimed at advancing legislative amendments that will provide reparations for civilians harmed by the UK's involvement in warfare. The project is funded by the UK Research and Innovation Arts and Humanities Research Council. In today's episode, we'll be exploring the Dutch approach to redressing civilian harm and looking at what the UK can learn from the Netherlands. I'm joined by Erin Bijl, who is a project lead within the Protection of Civilians programme at PAX. I'm also joined by Steven van der Put, who is a legal advisor at the Royal Netherlands Air Force. Civilian harm caused by the Dutch military is at the forefront again in the Netherlands. We're recording in April 2025, and just last month, the Dutch cabinet released a letter to Parliament responding to the report of an independent commission of inquiry into the deployment of weapons in Hawija, which was published in January this year. In the letter, the Dutch Defence Minister accepts all of the recommendations made by the Commission. Also, in the past few weeks, post-strike video footage that was previously declared lost has been found by the MOD, reigniting calls for further investigations. Welcome both of you to the podcast. Thank you so much for joining me. I'll just start with a small disclaimer as well about my voice. Apologies, I've lost my voice, so please do bear with. So before we turn to Hawija, Steven, could you start by giving us a sense of the key trends in how victims are receiving compensation for harm caused by the Dutch military?
Sure, May. And first of all, thank you very much for the invite to participate in the podcast. I also must start with a small disclaimer myself that I'm here very much in a personal capacity and that any statements I make do not necessarily represent the viewpoint of the Dutch Ministry of Defense. Having said that, though, what we can see whenever we look at especially the concept of accountability in the Netherlands is that we've seen quite a switch here, whereas previously and almost traditionally, many of these processes were associated with criminal proceedings. We've now started that this has led to much more civil litigation, and we've seen a very broad trend almost developing there in which victims have attempted to use civil law to hold the Dutch state accountable. And some of the almost landmark cases which kind of seem to have started this movement, we can find whenever we look at the cases arising against the Netherlands from Srebrenica, in which we have the Nuhanovic and Mustafic cases, and also the Mothers of Srebrenica cases, in which the victims all attempted to use civil law to hold the Dutch state accountable. And we've more recently seen this in the Chora case as well. And then, currently still ongoing, we have the Hawija case as well. And what's really key in these cases is that Dutch civil law provides for a very broad definition on what constitutes a wrong under civil law. Under Dutch civil law, for an unlawful act which can be attributed, the party should also compensate the damages. And then it offers also a very broad definition of what this unlawful act entails. And the Dutch law states that this would include any infringement of a right. And courts have generally accepted that this also includes international legal obligations for the Dutch state during military operations abroad, obviously providing that these international legal obligations are actually applicable. So that would include also violations of international humanitarian law or international human rights law. And this, combined with a relative accessible court, has led actually to many cases being held against the Dutch government for where victims felt they have been harmed as a result of the Dutch forces. Besides these domestic cases, we've also seen that the Netherlands have engaged with the concept of ex gratia payments. These are broader than the legal violations, as these represent non-legal compensations for damages. So, importantly here, individuals would not need to prove a relation with a violation, but it would be sufficient for them to argue that they have been harmed as a result of Dutch military operations. Up until now, these have been relatively ad hoc, and they've been based on the operation, and Dutch policy has been developed depending on the military goals or the operation, or if they are likely to contribute to military success. There have, however, been some elements visible, and for example, when we look at the Chora case, here the court considered, or mentioned at least, that the damage had already been compensated through such an ex gratia payment. And in doing so, the court highlighted a few elements which the Dutch military employed in Afghanistan for compensation. The court mentioned here, for example, that there was contributions made by the Netherlands towards reparations of infrastructures, compensation for injury, and loss of income and agriculture, as in livestock or agricultural equipment. More recently, however, we've seen some further developments here. Erin might highlight this also later in the episode, but we have seen that the Dutch Ministry of Defense have started a so-called meldpunt burgerslachtoffers in Dutch, or reporting point for civilian victims of Dutch military actions. It has been mentioned in the response also to Hawija that this would include possible ex gratia payments if this was led towards Dutch military actions. We've also seen in the Hawija response that there have been some developments mentioned towards Dutch policy regarding compensation, in which the minister states they will install a transparent general policy for compensation for future military operations. Policies regarding compensations will be discussed in Parliament pre-deployment, even when risk of civilian harm is considered minimal. And the Netherlands are going to draft a letter of intent for the international contact group to share and discuss this issue further. So I think these are kind of the broad general developments we have regarding compensation for civilian harm in the Netherlands at the moment.
That's great. Thank you so much for the very sort of comprehensive overview. And I was, conscious that you said up until now, because it seems as though we're really at a moment where things are sort of changing. And you mentioned as well the Hawija case, and it's very interesting because we had a few different approaches to addressing sort of harm in that case. You mentioned some of the litigation that's still ongoing, but something that sort of was also done is this community level response. And Erin, I'd love to bring you in on this. So you recently published a briefing on community level responses to harm in Hawija, which assesses the response of the Netherlands to the harm caused from the perspectives of the survivors themselves. Could you perhaps just start by telling us, for those who don't know, a bit about the incident itself, and then sort of introduce us to what was the initial response from the Netherlands government?
Yeah, of course. And thanks so much for having us on this show as well. So if we're talking about the Hawija case, we're actually talking about an incident that happened almost 10 years ago today. And I would say sort of part of the reason that we're still talking about it in the Netherlands now, sort of 10 years after that actually happened, has been in part the result of the fact that the Netherlands, I would say sort of from Pax's perspective, has made various not very strategic choices sort of throughout the way of communicating and responding to this incident. But I'll sort of revisit that statement a little bit later. But sort of back to 2015, sort of at that time, the Netherlands, like the United Kingdom, like the United States and various other countries, was very much involved in this international coalition to fight the Islamic State in Iraq and Syria. And in June of 2015, sort of as part of coalition operations, the Netherlands then carried out airstrikes on a building in Hawija, which is a city in Iraq. And this building was in use by the Islamic State for the production and storage of vehicle-borne improvised explosive devices, so VB-IEDs. And essentially what happened and why Hawija has become such a big incident since is that there was a very large amount of explosives stored in this target building, much more than anticipated, we later heard. So that when the Netherlands actually struck the target, what we saw there was this big, not anticipated secondary explosion. And just to set the scene a little bit, we're really talking about a very big explosion here. So it left a crater that was 11 meters deep. We heard that sort of the impact of the shockwave had a diameter of more than 5 kilometers. And by the time that we did research, which for Pax was in 2021, we actually heard a lot of accounts of people also in villages and cities quite far removed from Hawija who sort of maybe up to 50 kilometers away, still felt the impact of the explosion as if there had been sort of this minor earthquake happening. If we actually spoke to people in Hawija themselves, they really described it as something that they had never experienced the likes of before. And of course, these were people that had actually been living in a state of armed conflict for quite some time by then. A lot of them describing it as if they felt like a missile had directly hit their homes, even though they actually lived quite some distance away from the target site. I'm saying all this to sort of paint the picture a little bit of what it did in terms of harm and damage. So again, this building, sort of this VBIED factory, was located in what we've often called an industrial zone or industrial neighborhood. And here I think it's just worthwhile to point out that that is a slightly misleading term I always find here in the West, because we often think of these very clinical spaces that are just for industry, but that don't really have sort of a lot of civilian life in them. And what we see if we look at Iraq and sort of the way an industrial zone is understood there, it's very much more sort of this area of commerce and industry. So there may be shops, businesses, factories, but there's also people living in this area. So for instance, you might have your shop on the ground floor, but then people, families living sort of in the first floor above it. So that neighborhood got entirely destroyed because of the secondary explosion. And what we've seen at the same time is that sort of this area was also surrounded by 3 sort of more purely traditional residential neighborhoods that also got damaged to quite some extent. So in 2021, we went to Hawija to conduct field research. We interviewed a lot of people who had witnessed the strike and lived through its impact. And we in the end came to a fatality count of at least 85 civilians who died as a direct result of the airstrike. And I will say that sort of we also found at the same time that is still quite a conservative estimate. Because for instance, one of the things that we saw is that at the time of the airstrike, there were a lot of internally displaced people living in the target area, or at least in that surrounding neighborhood. So a lot of these people are expected to have died as a cause of the explosion. But these were people that, because they had only been living there for a short time, weren't really known to any of the other people in Hawija, so have later never been identified or claimed as one of the casualties. So really stick to sort of these 85 civilian casualties that we could confirm through 1 or 2 means. In addition, we've seen that hundreds of people were injured, some of them quite sort of permanently or in a life-altering way. We sort of received reports of damages to up to 6,000 houses, more than 1,000 shops and businesses, as well as just widespread infrastructural damage to several schools, electricity infrastructure, factories, the civil defense. So it was really sort of a huge impact. Maybe sort of a final note on impact, because what I do always find important to highlight, like we went there explicitly with the intent, let's map sort of the direct impact, but also the indirect or reverberating impact, because that's often not really included in these kinds of discussions. And what we saw then, that because of the level of destruction to people's homes, to people's businesses and shops or places of employment, we see this really sharp increase of displacement as a result of the airstrike. Decreased availability of healthcare, because some of those facilities have been hit and damaged as well. Widespread economic harm and a related increase in child labor, for instance, but also quite crucially, really widespread psychological trauma. So of the more than 100 people we interviewed, I did sort of the analysis of the interviews at the time, what was very sort of clear was that almost all of them, or I would say actually all of them, pointed to sort of signs of mental trauma. So this is really still quite an ongoing problem. And even now, we had a colleague traveling to Hawija just a few months ago, earlier this year. And actually a lot of the material damage that was done in 2015, you can still see that today, because not all of it has been cleared up or repaired. So it was really, really big in terms of impact.
Yeah, and when it comes to investigating the incident, you mentioned there at the start that sort of it came to light later that there was much more explosives being stored than was anticipated. So were investigations begun quite quickly after the incident? How long did it take for the Dutch military to sort of acknowledge the extent of the harm and begin to thoroughly investigate what had happened?
Yeah, that's a really good question. And it's actually in that question, that is also the reason of why did we as an NGO decide to go there and do this field research. Because in terms of sort of civilian harm response, I feel like we often immediately jump to financial compensation payments, but like you sort of referenced yourself, acknowledgement is a really big part of it. And it's also quite consistently sort of one of the top priorities for civilians harmed over the course of military operations to find out what happened, why was I or why were loved ones harmed. And it is here that we see sort of the first, at least publicly, we see the first problems with the Dutch response, because while the airstrike happened in 2015, and we knew sort of the international coalition at large is responsible for a civilian casualty event, we didn't actually know it was the Netherlands until late 2019. That's when the Dutch government took responsibility following reporting by Dutch journalists about this. So you have to imagine that sort of for this span of 4 years, people who actually lived through this really traumatic incident, they didn't really know where to go for information or who had been responsible, while still also dealing just with the very material and very physical aspects of it all. So I would say there's maybe two ways to look at acknowledgement, because yes, on the one hand, the Netherlands acknowledged responsibility. The Dutch Ministry of Defense wrote to Parliament acknowledging that it had done this. But this is sort of a Dutch piece of writing in a Dutch political system, and it's not really the same, I would argue, as acknowledging something directly to those people who were affected. So that at that point hadn't really happened either. And what we saw quite clearly immediately sort of in the political discussions following this acknowledgement was this uncertainty about, okay, can we actually know how many people have died and how many of the people who died because this was an ISIS-occupied area, how many of those were IS fighters as opposed to civilians. And it was in this that the Netherlands quite consistently maintained we cannot know all of this and it's too unsafe for us to go do an investigation into this. That really bothered us because I think at that time we felt the debate in the Netherlands was very much focused on which sort of political person had which information at what time, which is, don't get me wrong, like really important for domestic accountability and transparency processes. But it kind of left this whole narrative about what has actually happened in Hawija and to the people there a little underexposed. So that's one of the reasons that we went in there. I will say, though, later, especially now with the report of the Commission of Inquiry that has been mentioned a few times, there has been some new information which, again, retroactively, unfortunately, has been quite damning for the Netherlands in the sense that the report is quite critical of the fact that the Netherlands, despite having indications of civilian harm, quite consistently denied that harm was caused in this airstrike. And this then also impeded any kind of real full-on investigation into what had happened. So I think in the report what is mentioned is there is an informal internal investigation. And it's quite critical of the fact that the Netherlands didn't sort of go beyond that and follow that up with a full investigation as well.
There has been a response sort of from the Netherlands in terms of responding to the community in Hawija. And this is what I really wanted to ask you about, is that we've seen sort of a reconstruction project. You mentioned the sort of thousands of shops and homes that were destroyed, as well as the people who lost their lives. I wanted to ask you, from your experience with speaking to the survivors, what's their perspective on how effective this type of response has been? We talk often a lot about the financial compensation or payment. And I wanted to ask you how this, instance of more community level response has been received by those, impacted, and whether it's actually addressing their needs and what their perspectives are.
Yeah, it's quite interesting. And I think, first of all, it has been good that the Netherlands, because it already sets the Netherlands apart from quite a few other states, it has sort of shown up in that sense and has attempted to really do something for the community. At the same time, I find it difficult to be very positive about this exactly because we sort of did that research from the perspective of survivors to see, first of all, was it effective in meeting their needs? Was it meaningful as a form of compensation? And the evidence is just overwhelmingly that it wasn't, and that the community itself really isn't pleased with this approach. And I think we could have known that as well. So maybe to introduce and contextualize that a little bit, sort of once we found out sort of the Dutch government took responsibility for the Hawija airstrike, there was quite soon this debate on what can or should the Netherlands be doing in terms of making amends and to help those people it had harmed. And the line of the Netherlands quite consistently has been since then that it doesn't really want to pursue individual voluntary compensation payments, because if you sort of read old letters to Parliament, it sort of talks about setting an undesirable precedent, as well as highlighting a number of reasons why practically that will be difficult to achieve. Like, how do you find out who has been harmed? How do you prove it? Those kind of things. From, again, Pax's point of view, that is a bit problematic because as soon as we started doing interviews with people on the ground, it was very clear. We directly asked them, how should the Netherlands be taking accountability for this from your perspective? And the answers were overwhelmingly like, we need a culturally appropriate acknowledgement and apology, and we need individual financial compensation. And there's a few reasons for that, right? On the one hand, people already at the time flagged that if we're going to be doing community level reconstruction projects, or if the Dutch government is going to be handing money to the Iraqi government for compensation or to big international organizations, we are just really concerned that that money will not actually end up with us, because it will sort of disappear along the line with corruption. And we have actually quite a bit of evidence that this has, in fact, also happened. The second reason, and I think that one too is really important to highlight, is that people said people have all been harmed in different ways and to different degrees. So, for instance, you might have a man, Abdullah Rashid Saleh, who over the night of the airstrike lost 5 of his children. They all died, and some of them still had also expensive medical treatment. You also have stories of, for instance, Reem, like a young girl at the time of the airstrike who got permanently disabled, so is now struggling to make a living for herself. But we also have countless of these stories of families who lost their access to income because the shop or the factory in which they worked no longer existed. So you can't really, like we have this saying about comparing apples with pears, like you can't really find one solution that is going to be applicable to all of those. So people immediately said, what we actually need is individual payments that are tailored to our needs so that we can also spend it according to the way that we see fit. For instance, again, another example, what do you do with people who have already incurred very high medical costs, but then tell them, well, we can't actually compensate you retroactively for that? Those are all, I'm not saying those are easy questions for a state to grapple with, like I don't want to downplay it, but from a victim perspective, those are really important. What we then saw in terms of the Dutch response, they proceeded to go ahead with community level reconstruction projects through big UN organizations, IOM and UNDP, which were more focused around this communal infrastructure aspect. And to give the Netherlands some credit, they did really look at NGO reporting on what are some of the needs that arise in Hawija and what are the types of harm that we actually see. So one of the things they said, well, if we've damaged this really important industrial zone, then maybe we need to invest in reconstructing and repairing shops. But also the electricity infrastructure got damaged, so we'll repair that. And I think the problem there is they've been to some extent effective in doing that. But what we have seen is that the people who've actually benefited from those projects and the people who were harmed by the airstrike directly or indirectly, there's been very little overlap between the two of them. I think our interview is estimated at 5 to 15% maximum. So that already is a big problem. And just to highlight it, I think one of the cash for work programs by IOM, it selected people to be eligible based on a vulnerability criteria. But those criteria most likely did not include an explicit link to the airstrike. So in fact, everyone was open to apply and to become a beneficiary, which kind of made those projects more general development aid and not a response to harm caused specifically by the airstrike. The second really big problem that we saw is that the Dutch government didn't really think to communicate clearly to the community in Hawija that it funded these projects and why it was funding these projects. So what all of the people who were affected that we spoke to told us, they actually didn't know that the projects that they were seeing around them happening, that they were funded by the Dutch, or if they knew that they were funded by the Dutch, that these were in response to the airstrike. And that is quite concerning, and I think also just for the Netherlands, something that they could have easily remedied, but it's very disappointing because any kind of reparative aspect from these kind of projects then immediately is lost because you don't really communicate about it, which is just a shame in that sense. And our conclusion from the research, and you can also read about it online, of course, is probably the most likely reason why we see some of these challenges and things that go wrong from a victim perspective is that the projects didn't really meaningfully involve any local authorities that were relevant to the community, or maybe even a few representatives of the victim group at large. So people weren't really involved. And that is most likely also why we see that these projects in the end were just quite a mismatch with what people actually needed and wanted from the Dutch in that sense.
It sounds as though, it's important to have a range of different tools within the toolkit to sort of respond to the harm that's been caused. And although this was sort of perhaps well-intentioned, it didn't respond best to those victims. Stephen, perhaps I could ask you a little more on what's happening on the litigation side in terms of the Hawija case. And when we're looking at sort of a more holistic framework, how are all these elements fitting together? And would you say, you said previously the response has been quite ad hoc. Are now things starting to become sort of more formalized in terms of having a policy or a framework around responding to incidents?
So what we've seen is actually, I'll take the question actually in two parts, and I'll first briefly sketch out, and related maybe also slightly to Erin, but I think maybe what she highlighted, some of the grievances regarding individual compensation, might have also actually ultimately led to many of the civil court cases. As in, I think this is then, if you don't get the individual compensation as a matter of policy, the law is a sort of remedy here, which does enable you to put forward these individual cases, which I would highlight is quite unique in the Dutch legal system, as in not every state has recognized that this is a possibility. For example, if we look at Germany or the US, we quite often see these cases being thrown out on the grounds that they argue, for example, that international humanitarian law does not necessarily contain an individual right to reparation, and therefore the court will not consider the cases at all. So this is an alternative way for them to perhaps, get their remedy after a court procedure, depending on what the judge decides in the case. But what we've then also see is actually that after the Hawija cases, that there has been very much a push towards transparency by the Dutch government in many of these cases. They've released a data set containing the deployment of weapons by the Netherlands during Operation Inherent Resolve, which lists the use of weapons by the Dutch Air Force during the operation, and that's publicly accessible. And then obviously we have that reporting point, which I think is quite a unique development, in which people can pretty much just log into the Ministry of Defense website and say, hey, I think I've been harmed by the Dutch military, upload photos, upload a brief statement considering, and then the ministry will look at it and compare it to their internal data sets and see if there's a possible relationship between those. So I think these highlight how there has been a push towards more development. Worth highlighting here is also that there has been a very conscious effort by the ministry to also make civilian harm a focus point, starting to employ policy workers on the specific topic and developing these mechanisms and responses further and further, and taking them in that sense very seriously and looking how to progress for the future.
Yeah, and I agree. I think we have seen some really positive development. I mean, of course, it can't be forgotten the immense suffering that the victims still continue to face. But I think it is worth recognizing the fact that we are seeing some sort of positive developments. And it's great to see accountability, transparency, acknowledgement really being centered in the approach that the Dutch are taking, which brings me to the UK, where we've seen sort of repeatedly this issue of sort of lack of transparency, reluctance to acknowledge violations, sort of the servers going missing, failure to cooperate with sort of investigations. Sort of the UK has, for example, admitted to killing only one civilian in their air war against ISIS, when from research from Ceasefire, we know that the figure is almost certainly much greater. So in the UK, there is still a lot to be done. And Erin, I wanted to congratulate you on the launch of the Civilian Protection Monitor just a few weeks ago, which is the result of a collaboration between Airwars and PAC. And it's a really excellent tool which enables this more comparative approach between different states. And, learning lessons much easier. And Stephen, you and I are working on this project together about how the UK can learn from the Netherlands, but also from other states, including the US. So, Erin, perhaps I can start with you. So one of the current 5 indicators of the CPM is this post-harm response. Just very briefly, how does the Netherlands compare with the UK, for example, on this specific indicator?
Yeah, thank you, Mae. I should say we're really pleased that we've finally been able to launch this project, which had been some time in the making a couple of weeks ago. And specifically for people who are interested in learning a bit more about what it is, the results that we have, but also how do we actually get to the results. Because we could, I think, fill an entire podcast with just that. You can definitely also just go to our website, civilianprotectionmonitor.org. If you allow me a short plug.
Yeah, cool.
But then, specifically on post-harm response and how the Netherlands compares to the UK. Like I said, I won't really go into full detail here on how our assessments work or how we get to a particular score. But essentially what we do in the monitor is that we characterize state performance in a few key areas of civilian harm mitigation and response. And then we characterize that response according to one of 5 what we call leadership categories. So going from the worst you can do as a state to the best that you can do, we could either classify you in the system as being regressive, uncommitted, engaged, an emerging leader, or a leader on a particular topic. And from our analysis, we've come, specifically related to post-harm response, we've come to a result where the Netherlands scores engaged on this topic. So we do say that because we actually see that the Netherlands is acknowledging harm, it's trying to engage in response mechanisms, like Stephen referred to multiple times. The reporting portal is a really important step as well, and quite unique internationally, or at least for the way it is set up. But it's also not scoring higher because it's not really acting. So because Dutch responses are still quite ad hoc, the Netherlands would say they're on a case-by-case basis, but that still means that there's not a lot of guarantees that you'll have as a civilian on how your case will be handled, so to speak. And it's not always according to their needs, but still a relatively good score. The UK, in contrast, we've classified as uncommitted. So that's there is one category below that, but it's still, you could say it's not good enough, what the UK does in this area. And that's actually quite disappointing. And I know you also touched upon this in the first episode of your series too, but historically we have seen the UK perform much better on post-harm response than it currently does. So we know that from past military operations in Afghanistan and Iraq in particular, the UK would quite routinely, maybe not routinely is not the right word, but it would on a more or less regular basis provide financial payments to civilians harmed over the course of UK military operations. That's not to say that was a perfect system. It wasn't always applied consistently, but it is a lot better and in really sharp contrast to actually what we see the UK approach being now, which is, according to what we could find publicly, there is not really any kind of system in place to provide financial payments or other forms of response. So that has meant that as we've moved away from those more on-the-ground operations in Afghanistan and Iraq to participation in the international coalition, which was much more remote, we've not really seen any kind of acknowledgement of civilian harm from the UK. You mentioned that one single civilian casualty, which, again, like you said, it stands in contrast to what independent monitoring organizations find in relation to the UK. And I believe even that single casualty, it's quite unclear where that comes from. And there's competing accounts of it according to the US, who did the recording of casualties for the coalition and the UK as well. So it's a bit of a strange case. I would say what's even more contributing to their score of being uncommitted, which of course is quite a harsh classification in that sense. But we've also seen that the UK has actually taken steps that make it more difficult for civilians harmed in conflict to seek accountability or to seek information from the UK. So we have the 2021 Overseas Operation Act, which actually sets this 6-year time limit for bringing civilian claims to the UK in relation to British overseas operations. That is quite concerning because at first, hearing you might think, okay, 6 years, well, that's quite a lot of time. But of course, armed conflicts are ongoing. They may last for years itself. But we also really often see that information may only come to light several years after the fact. Like I said, specifically in relation to the international coalition, it took 4.5 years for the Hawija airstrike to be linked not just to the coalition, but to the Netherlands. So that means that this is really an obstacle to accountability in the UK. So it's quite a problematic piece of legislation. What I will say is for this score, we had to take a particular moment in time. So we only included information up until the end of January of this year, and also only information that is public. So that has meant since that in a way, actually the Netherlands would probably score a little bit better than it does in this framework. Because we've since seen an apology for Hawija, we've seen the announcement of at least exploring options for further conversation. But we also know that there is some movement in the UK, or at least we're hopeful to see some movement. We know, for instance, that UK MOD policymakers partake in these international discussions on civilian harm mitigation and response topics. I believe the UK MOD is also in this process of conducting an assessment of its civilian harm mitigation and response capabilities and policies. And has actually also invited civil society to contribute to that assessment as well, which I think is really good. So we do have some hope that maybe whatever that assessment will lead to, whatever it will find, it will usher in this renewed commitment of the UK to post-harm response. But yeah, at the moment, they don't do very well.
We can only have hope perhaps that in the next few years we'll see some sort of policy or framework from the UK. Stephen, from your perspective, what do you think the UK could be doing better, sort of as we're in this period of, as Erin mentioned, doing sort of the baseline study, as a joint project, we're exploring options for how the UK could strengthen its approach. Where do you think are the key areas that the UK could learn from the Dutch?
Well, I think many of those key areas quite directly relate to many of the points Erin was making as well. And I think one of the values here would be, obviously an increase in transparency. And as highlighted, it's pretty much impossible to get sufficient legal evidence to be able to start proceedings within 6 years, especially if you look at longer ongoing armed conflicts, which would make that very, very difficult. And I think lessons can be drawn there from the approach the Netherlands has taken and the reception that has gotten and how these things can progress further. I think an understated point, and which I think there's some developing mostly academic literature on that, but is also in the value of civil law when addressing these violations. I think whenever we still look at this, and for example, if you look at the SAS inquiries and things like that, there's a very much an emphasis on criminal proceedings, which often quite leads to almost the closing of the ranks. People start getting individualized and people start really almost, I don't want to use very determinative words, but like hedging their bets or making sure their safety is because, criminal proceedings against the individual affects the individual very directly. Whereas it might also be more valuable in this case is to look at civil law to uncover many of the elements Erin was highlighting as well. It can uncover a bit of truth. It can also enable a broader evaluation of procedures, not just limited to individual actions. The burden of proof is slightly perhaps more realistic when we consider the context of armed conflict, where we can look at the difficulty of proving, for example, criminal intent whenever we need to deal with these things. So I think these are all valuable additions that a more engagement with civil law litigation could also have. And I think that is, in that sense, would be worthwhile developments perhaps for the UK to consider in this situation.
Can I just ask you, in sort of the civil law cases, are we talking about like responsibility versus non-responsibility? Are the Dutch, is there liability for the harm caused in civil cases?
You mean as in the Dutch legal system, it has directly led to compensation in many cases, as in the state has been held liable to then, if a violation has been found, to compensate. It's not always full compensation. This is one of the particularities of how Dutch civil law works. So the court would also consider, for example, the risk a victim would have to otherwise have survived the action if the illegal act didn't take place, which was a big sticking point for the mothers of Srebrenica cases, as the court granted them compensation, but only partial compensation, because they said even if the Dutch state hadn't committed the violation, the chances of the individuals surviving there was actually quite small. So they only awarded partial compensation. But in general, yeah, it would lead to compensation. It's just dependent on the specific of the cases, what that compensation looks like.
Well, thank you so much, both of you, for these really interesting insights. I think absolutely this is a crucial moment for sort of looking at how states and militaries respond to civilian harm. And there are so many lessons that can be learned looking at comparative practice. So both of you, I really appreciate your expertise, both in the Netherlands, but also in the UK as well. And it's been really great to have you both on the podcast. So thank you again for your insight. Thank you for listening. See you next time.